All right, our next case is Lake Sioux Development versus KEEWIN Real Property. Kelly?
Please court. I'm Robert Reynolds, attorney for the appellant, Lake Sioux and commercial realty appellants. We stand before you on a case that comes.
Let me ask you something. Is the clock working?
No, Your Honor.
You want to reserve any time for
8 minutes, please, Your Honor.
8 minutes?
Thank you.
Go ahead.
Thank you, Your Honor. We're here on a case that was entered summarily on a final judgment that was based upon a claim by appellee KEEWIN for the entitlement of a broker's commission of approximately $200,000. And this claim is based upon an exclusive listing that was in writing, but that had expired several months, in fact more than 6 months prior to the time that the written brokers.
Can you extend an exclusive agreement or an exclusive right of sale agreement by oral?
I believe you can.
Condition?
I believe you can.
So your argument is that the facts are just not crystallized enough on that oral extension to grant summary judgment, that that's a jury question.
It is a jury question. I believe our best case to support that contention is the case of St. Joe, which is a Florida Supreme Court decision that says that those kinds of issues are typically, usually, I think is the language.
As I read the transcript, it looked to me, or the record rather, it looked to me like the contravention of the allegation that the agreement was extended came from an affidavit filed by your client with the court, or the principal of your client's with the court. I was a little puzzled about the timing of the affidavit. It looked like it came in on a motion for rehearing of the summary judgment. Am I right on that?
That is correct, Your Honor. Actually, that was the second of two affidavits. That was the more elaborate of the two. Having said that, however, the rehearing is somewhat misleading. That term is somewhat misleading because the judge that entered the first judgment was recused, and therefore that order was of no consequence legally. It was void.
Right. So the consequential summary judgment was actually the one on the rehearing.
Correct. And actually there were 3 orders that were entered by 3 separate judges. The first judge who was recused because the appellee's counsel had an ex parte communication, and that lawyer actually took over as a circuit court judge in that same courthouse for that particular judge that was recused.
Well, of course, they're going to say, I guess one of their arguments is that your client's affidavit was inconsistent with his deposition testimony, and I think the law says you can't, recant sworn deposition testimony with an affidavit. Why don't you address that for me?
Thank you, Your Honor. And certainly that is a law, but that's not the case here. The facts simply don't fit into that particular legal theory. Not only is there not an inconsistency, and there was only actually 2 lines. I think we addressed this fairly exhaustively in our initial brief. The only testimony that has been identified as being from the mouth of Mr. O'Brien, who was also the affiant and who was the representative of both of the appellants. That testimony is 2 lines saying that he would not disagree with the testimony of the principal of the appellee if the appellee said that the extension was in effect, or that there was actually an extension of words to that effect. That doesn't get anyone anywhere to simply say that he wouldn't disagree with him. I think we...
Well, he is now, but...
Well, no, actually, I mean...
He did in the affidavit, right?
Well, I think the affidavit simply goes into kind of detail that the testimony on deposition did not. The testimony on the deposition simply said, I'm not going to disagree with him. Doesn't mean I agree with what he's saying. I'm just not going to sit here in contempt. That particular statement is subject to many, many different kinds of interpretations. Certainly not something that you can hang your hat on for a $200,000 commission. I mean, there are people who are polite and people who aren't polite. This particular gentleman who sat there and had his deposition taken and answered that one question out of a whole 2 or 3 different sittings on his deposition should not have I won't call it an offhand remark, it wasn't, but it certainly was a remark that did not cover the waterfront. It's a remark.
He's saying I'm not going to call him a liar, is that what he's saying?
I think that's a fair interpretation. And I don't believe, and that creates an issue of fact, and that's what juries are for, and that's all we're seeking is to have a jury trial. We don't believe that summary judgment where there was a commission paid. So this isn't a case, as in the typical case, where there is an effort by the appellant to avoid paying a commission. And it was a commission that approximated in dollars the same amount of commission that would have been paid had this commission been appropriate.
At the summary judgment hearing, was the argument made that the affidavit was inconsistent with deposition testimony, or was the argument made simply that it wasn't sufficient or there wasn't any material issue of fact?
Frankly, I don't recall precisely, but it's my recollection, having been there, that that argument was not made with any kind of force. I certainly will defer to counsel making a record reference to that.
So you're not going to call him a liar?
Thank you, Your Honor. Touche. Will not. Nor because of the recusal would I call counsel unethical, because we simply don't believe that to be the case. We simply believe that what happens as the legal effect of recusals is that the order entered by the judge who is recused herself has no force and effect, and therefore that's left for the successor judge.
What happened to your counterclaim? Is that an issue on appeal at all?
It is not.
I didn't think so.
No, thank you. We believe that there are a number of different reasons, and we've set them forth, I think, fairly exhaustively in our briefs, both briefs.
Other than the issue of whether or not the extension was put into effect, is it your position there are other disputed issues of material fact that preclude summary judgment?
Thank you, Your Honor. Yes, there are. We believe that, for instance, the appellee ceased workings well before the time that a contract was entered into with the ultimate purchaser, and that ultimate purchaser was not a purchaser that was procured by or even mentioned or referenced by the broker. There was a
It doesn't have to be if the exclusive right of sale agreement is still in effect. Right?
That's certainly true. I believe that is the language of that particular listing, and that would be the case.
He obviously worked beyond the express expiration of the exclusive right of sale agreement, but your position would be that at that point it was just kind of on an open listing basis?
I believe that's so, and the law is clear. Thank you, Your Honor. The law certainly is, and under St. Joe, which makes this kind of issue a factual issue for jury determination or for determination of the plenary hearing, that the broker can't just simply keep working. That's not good enough. Working for what, until when, and toward what purpose? The broker actually was performing many things for different tasks. The broker, in fact, presented a claim for itself as a principal, and we have addressed that as a breach of a fiduciary duty. We think the Young case and the Torburn case and the other cases that address those issues are clear that you can't have it both ways. And, of course, the broker is simply saying, we're just here trying to help out. We just say, if you didn't want to sell it to us, no harm done, no harm, no foul.
I think it's a breach of fiduciary duty for an agent to offer to the principal that, we'd like to buy the property from him.
Not just in and of itself, but under these facts, absolutely. And the facts are that the offer was for 25% of the purchase price that occurred 3 or 4 months after that. 25%.
So what? These are big boys. They're dealing arm's length, and there's no allegation of any side dealing here, or that the broker's involved with somebody that's making the offer, that they're doing it through a straw man. This broker's going right to his principal and saying, I'll buy it from you, and if the principal doesn't know what the property's worth, I mean, who does?
Because even though they're big boys, this big boy played in a different arena and wasn't a big boy in this arena. That's why he had these brokers. He relied upon these brokers. They gave him pro formas that said, hey, this is the scenario that's most likely, and we're here to tell you that it's going to take 5 years before you'll see a penny out of this project, and you're better off selling it to us. Now, does he have a right to rely upon that representation or not? I believe the answer is yes. If the answer is yes, and if that representation is materially false, which it was by definition, because 3 or 4 months later, there's a sale for 4 times what that offer was.
When did they make that representation?
After they stopped working on the property, according to Mr. Folks.
So if they were no longer the broker, they had every right in the world to make that representation.
Sure, but either they were the broker or they weren't. If they weren't, then the listing was in effect, and they're not entitled to the commission. If they were the broker, then they have a conflict and a breach of a fiduciary duty. So if it was in effect, then there's a breach of a fiduciary duty.
What's the remedy for the breach of a fiduciary duty?
Under
the forfeiture of the commission?
It is, Your Honor. That's precisely the remedy.
And where does that come from?
And what case law supports that proposition beyond case, Your Honor?
You don't have any cases, though, that say that it's a breach of fiduciary duty for an agent to offer directly to the principal to purchase the property for less than fair market value.
No, in fact, I don't believe that is a breach of fiduciary duty, simply stated. That's such a general proposition.
The misrepresentation was really an opinion about value, right?
Well, obviously, if it's merely an opinion, but it can't only be an opinion, because if you're a broker, you're not entitled to simply express opinions and then hide because those opinions are so...
At the time that they made the alleged misrepresentation, hadn't they already presented a contract to the principal from one of the other builders, or am I mixed up?
They had presented a contract that was actually in effect at the time with Cambridge Homes, and that contract was not consummated because of Cambridge Homes.
Was that contract for a greater price or a lesser price than the broker offered?
That contract was for a greater price, I believe, but it's apples and oranges, because that was for only one of the 3 phases, for only 100 of the 1,000 homes.
All right, sir.
172 or something.
141.
Thank you very much.
All right.
Good morning, Your Honors. Bart Valdez on behalf of KEEWIN. This is a case where the developer is simply trying to get out of paying under an exclusive right of sale agreement.
Why isn't an affidavit which says we didn't extend the contract enough to avoid summary judgment in this case?
Because under the law of the state of Florida, you cannot have an affidavit that contradicts any sort of deposition testimony merely to try to get out of summary judgment.
Was that argument made below?
Absolutely. And more importantly, one of the arguments that was made below was when you have one person that remembers a situation and testifies to that, you have another person that says, I can't recall that happened, then the law says that the only admissible evidence of what happened is the person that recollected what actually happened. And so if there's a situation where Mr. O'Brien is testifying, saying, I don't recall whether or not there was an extension, Mr. Folk, the principal of KEEWIN, says, absolutely, there was an extension, we continued to work on the property, then the only evidence that the court can consider is the person that actually recollected.
Would you agree that Mr. O'Brien's affidavit would have been sufficient to defeat summary judgment but for his deposition testimony?
No, because there's additional testimony out there as well. There's what I call...
What difference does it make if there's additional testimony as long as there's some testimony on the other side?
Because the only testimony on the other side that was an attempt to contradict what the other...
No, you stick with my hypothetical.
Okay.
If all you had from O'Brien was his affidavit, no deposition, and he filed the same affidavit, that would have defeated summary judgment, correct?
It could have, but that wasn't the fact.
It would have, right? It would have created an issue of material fact, wouldn't it?
As to the extension of the agreement, possibly.
Why only possibly?
Because you had to
Counselor,
look...
if one guy says it didn't extend and the other guy says it did extend,
Yes, I understand what you're saying. And yes, if that was the only evidence...
Then there wouldn't have been a summary judgment.
Yes.
Okay. Was there any motion made to strike the affidavit?
No, but the affidavit on summary judgment came after the original summary judgment was issued, and then it was on a motion for rehearing. And this issue about Judge Russell being recused.
Was any motion made to strike it because it was filed on a motion for rehearing, not at the original hearing?
No, there was no motion to strike, but the argument was made below that you cannot consider this affidavit because it specifically goes against what his sworn deposition testimony was. And the court understood and accepted the fact that when you look at the record and the deposition testimony of Mr. Folk, the deposition testimony of Mr. O'Brien, the conduct of the parties, including the correspondence from Mr. O'Brien, and the key thing to also understand, Your Honor, is this was not an issue. The parties never disputed that the agreement continued. In fact, at the original summary judgment hearing, even counsel for Lake Sioux and CRG said they continued to work together. So this issue...
Did they say they continued to be the exclusive broker? Isn't that the key issue?
Well, the key issue is whether or not the exclusive right of sale, at least from the appellant's perspective, is whether or not the exclusive right of sale agreement remained in effect after its initial term.
And that's not disproven or proven by the fact that they said we continued to work together, correct?
It is proven by several things. First of all, the deposition testimony of several witnesses that said they continued to work together. The actual contracts with Cambridge and Ryland were both entered into after the initial 6-month term.
Either of which are inconsistent with them continuing to act as a broker, but not necessarily an exclusive broker, correct?
Well, there was never any change, and it's important, Your Honor, to look at the agreement because the only way the agreement can be terminated is by the developer providing 30 days notice, and that includes during any extension term. There is no record evidence of any 30-day notice of any termination.
What was the extension term?
The extension term was until the property was sold.
It was an indefinite extension?
No, it was until the property was sold, however long that would be.
Well, that's indefinite, right?
It could go on forever.
Is it a defined extension?
Until the property was sold or until it was terminated by the developer under the terms of the agreement, which is providing the notice that's required under the agreement.
Well, I'm looking at the testimony of Mr. O'Brien that you say contradicts his affidavit, and I'm pondering that. He said, did you ever tell, or did anyone on behalf of Lake Sioux Development ever tell KEEWIN that the agreement was not extended beyond its initial term? I don't recall that I said that. So if Mr. Folk were to testify in this case that, in fact, you did have a conversation where the two of you discussed that, then you would have no information to dispute his recollection. No, I wouldn't. But that does not say that the agreement was not extended. It says that he would not testify that they did not have a conversation about that.
That's correct, and that goes back to what I was saying. When you have one person that says that I remember the conversation, here's what was said, here's what was done, the other person
he says I don't deny we had a conversation about that.
Right, he says I don't recall.
Then the trail of testimony leads. It was not finalized beyond that.
Right, because the answer was he didn't recall that conversation. He cannot then come back in an affidavit say, oh, I absolutely recall that we terminated the agreement. Once he testifies, he doesn't recall the conversation or that he doesn't recall the extension of the agreement. He cannot later come back and contradict that by giving an affidavit.
Why is it necessarily a contradiction? You could not have a recollection of having talked about it, but you know you never agreed to it. Maybe there was a discussion about it. I can't remember whether the subject ever came up, but I sure know I never extended it. Those aren't inconsistent, are they?
Well, I believe that it is. But additionally, there's other record evidence within his testimony where he testified that the contracts were entered into after the agreement. They continued to act as the broker and other things. Remember, this was a brokerage agreement that entailed doing things other than simply marketing the property as well. In fact, the brokerage agreement specifically said that they were going to help with development approvals, they were going to help get financing options, and all of these other things. And that's paragraph 8 of the brokerage agreement. It's also important to understand the reason why the agreement had to be extended. Originally, there was no road into the property. So this initial 6-month term became unworkable, and they had to extend it because they couldn't get builders in there. Secondly, there were delays
Did
with
your
recruitment.
client testify that he quit working on the project prior to the Miranda contract?
No, there was a statement from Mr. Falk that he stopped marketing the property once he realized that it was going to be sold to Miranda. But there are
I
other,
thought there was a statement in his deposition giving a time frame. My recollection is that it was something like November, December of 2000 into January of 01. That he said at that point in time, he stopped working on the project.
yes, and I'm familiar with the testimony you're referring to. In fact, that's the testimony that the appellants heavily rely upon to say that there's this material issue of fact as to whether or not there was a
Isn't that
termination.
inconsistent with an extension of the exclusive right of sale agreement for an indefinite term?
No, because he was only testifying as to the marketing of the property, but there were other items or other things that the brokers continued to do, and he testified about that in other points of his deposition. Additionally and importantly, the issue of
Doesn't that
abandonment.
create a fact issue?
Well, no, and
So,
no, because it only has to deal with marketing. The undisputed facts are that they continued doing other things with the property.
well, I mean, certainly one of his principal responsibilities was to, under an exclusive right of sale agreement, is to procure a sale, right?
That's correct.
Act the sale, or however you want to say it, cause a sale to happen.
That's correct. And what was going on is they had a letter of intent with Ryland. They had a contract with Cambridge, and that was approximately 250 out of the 400 units. And then CRG and Lake Sioux were going through financial problems. So they said, look, can you help us work through these financial issues because the development costs are starting to hit us now. Help me work through other things instead of just marketing, which is what they switched over and began to do. And that's ultimately what led to one of these proposals, which was never accepted to be a joint venture.
So do you think it was appropriate for your client to send a lowball offer, a 25% offer to buy the property?
Well, this is not, it's gross mischaracterization of what the offer was. It was $1.25 million plus assuming all the debt on the property. But aside from that, because that doesn't even, the facts underlying that offer are not this positive. The law in the state of Florida is that you can make an offer unless the offer, first of all, a broker can always make an offer if it's fair, if there's full disclosure. Secondly, unless the offer is accepted, then there is no breach fiduciary duty self-dealing. The principal case we want to rely on is the Young case. The Young case was totally different than this. In the Young case, it was one of those ready, willing, and able type contracts where the broker only had to go out and find a ready, willing, and able buyer. Well, the broker said, guess what? Near the end of the listing term, I'll put an offer in. The client said, no, I'm not going to accept that offer. The broker said, well, I was ready, willing, and able. You got to pay me a commission. It wasn't an exclusive right of sale agreement like this case. And so the Young's case, which the appellant just got up here and said is the main case he relies upon, has no application to the facts in this case. And there is absolutely no dispute that the offer was never accepted. There was no issue. It didn't go any farther than saying, here's $1.25 million. We'll take the debt on the property if you'd like to enter into a joint venture. It was never accepted. There was never any further
So
discussion.
even if there was a breach of duty, there was no damages. So you don't have a completed tort. Is that what you're saying?
Well, not only that, but there was no breach, and that you can make an offer. There's no, and I'm talking about as a matter of law.
I heard your argument that there was no breach. Your alternative argument is that even if there was a duty and a breach of duty, there was no resulting damage, so there's no tort.
Right, so no forfeiture of any commission because of some alleged self-dealing. Because the fact that they didn't take it, and the fact they didn't say, we'll accept it, or we want to continue on or enter into a contract, the fact that it was a mere offer with nothing else does not rise to the level of breach of fiduciary duty and breach of any duty or good faith obligation to forfeit a commission. And so going back to the St. Joe case, which additionally the appellants rely upon, that was a case involving a commission under a voluntary condemnation type situation. And the issue in that case was whether or not the parties had agreed that if the state were to buy the property, whether or not a commission would be sold. Again, it wasn't an exclusive right of sale agreement. And what the court said in there is, well, we'll go back and look at whether there's a material issue of fact as to whether or not the parties agreed that if we actually sold it to the state, then there'd be a commission.
Let me go back to the extension issue. What was your client's position of record as to exactly how the extension came about? Who agreed with who? How was it done?
Mr. Folk, as a principal of KEEWIN, agreed with Mr. O'Brien, as a principal of Lake Sioux and CRG, that they would continue on as broker until the property was sold. And so that was the extension, and they would continue that. The evidence of the extension is the correspondence between the parties, the conduct of the parties, the contracts that were entered into.
What was the consideration?
For the extension? Well, the consideration was that Lake Sioux and CRG continued to accept the fruits of KEEWIN's labor, and that's evidenced by the fact they got a letter of intent for 101 units and a contract for 141 units after the initial term. Additionally, KEEWIN kept working, gave them financing options, assisted them with the development approvals, going through the Seminole County development approval process, assisted with construction issues. And so that's what KEEWIN was doing in exchange for getting a commission.
And this is all based on a conversation between the principals of the parties.
Multiple conversations, and that's what the record says, is that there was ongoing conversations, there's ongoing conduct of the parties.
Back to Mr. O'Brien's deposition, because the key question is, did you ever have any discussions with Jay Folk concerning an extension of the agreement beyond its initial term? And the answer was, I don't recall that we did. It wasn't, I don't recall whether we did or didn't. I have no recollection one way or the other. It's, I don't recall that we did, which sort of sounds like a denial to me. Is that enough to create an inconsistency for summary judgment purposes?
Yes, it is, because under the law in the state of Florida, if you have a person that says, I don't recall, and another person that says, I do recall, and here's what happened, then the only competent evidence that the court or trier of fact can consider is the person that says they recall.
Isn't there a difference between I don't recall what happened and I don't recall that we did? That sounds almost like one way of saying no. Did you do this? No, we didn't. I don't recall that we did, as opposed to I don't have any recollection one way or the other.
Well, him saying I don't recall, we believe is equivalent in the cases to saying I don't recollect or I have no recollection either way. And his statement, if he remembered in his affidavit that it wasn't extended, then he could have said so in response to the deposition questions. And that's not what he
That's
did.
essentially what he did. He said, I don't remember doing that. Isn't that the same thing?
No, I don't think so. I think saying I don't recall having ever agreed, Mr. Folks saying that we extended it, I don't recall that we extended it, and then him coming in and saying we did extend it is inconsistent.
Well, what about the very next question that says, did you ever tell or did anyone on behalf of Lake Sioux ever tell Jay or Alan or anyone at KEEWIN that the agreement was not extended? And the answer was, I probably didn't think at the time that I had to, so I don't recall that I said it. If it just expired, it expired. Didn't that at least create an issue of fact on whether or not it expired?
Again, we believe it does not, because when you sit there and say, I don't remember if I did or didn't, I don't recall, and you have the other side saying, absolutely, I do recall, it did happen, you go back to that same...
But what he doesn't recall is whether they had a discussion about it. He was never asked in the deposition, did you ever agree, right? Isn't that a problem? It would have been real simple if the deposition question had been, did you agree with Jay Folk or with anybody to extend the agreement? And if he said, I don't have any recollection, you might be in better shape than if when the only question that was asked was, did you have a discussion about an extension?
Well, and, the answer is possibly yes, but the fact is we have the record which we have, and there was nothing in his deposition where he said, throughout his entire deposition, he never said, we terminated it, we agreed there'd be a termination, or I said there'd be a termination. Each time he was asked about this...
Wait. It terminates, it's a fixed time contract. It's a 6-month contract. He doesn't have to take any steps to terminate.
Yes, he does, Your Honor. Under the terms of the agreement, he has to provide 30 days notice at any time during the initial term or the extension. So he would have to provide a notice.
At the initial term, anytime during the first 6 months, or an extension beyond 6 months. But if it just expires at 6 months, it expires at 6 months. Otherwise, you got something violating the rule against perpetuity.
Well, sure, but the issue is that there's ample evidence in this record, and Mr. O'Brien admits that KEEWIN continued to help him secure the contract with Ryland and Cambridge, and there was never any...
Necessarily under this contract.
Oh, absolutely. I mean, he even
Seems to me a
said...
jury ought to decide that.
I'm sorry, Your Honor?
I said it seems to me that a jury ought to decide that.
Well, Your Honor, we think that the record's clear. 3 different trial judges have looked at this issue on rehearings and on motions and have come to the same conclusion.
Is it your position that absent an explicit extension agreement, that there still was some 30-day notice after the 6 months were up?
There still, pursuant to this agreement, has to be notice that it's going to be terminated before a termination is effective.
Even if they never agreed to an extension, and even if the 6 months have run out?
Why have a 6-month term if that's true?
Because you have to have some, well, the initial term, there has to be notice. There's no doubt about that. And even in an extension, and I understand Your Honor's question, well, if the agreement wasn't
If
extended...
nobody said anything, if they never talked during those 6 months, at the end of the 6 months, it's your position that the agreement continues in perpetuity until somebody gives 30 days notice?
Once they talk with each other or send letters to each other saying, you're my broker, please continue, we need your assistance, those types of things,
Listen
absolutely.
to my hypothetical. Assuming they never had any discussions after they signed the agreement, the 6 months run out. Is it your position that the agreement continues after that 6 months until somebody gives 30 days notice?
If there is no mutual agreement, then I understand, no, there would not be any extension. The contract says it's upon mutual agreement that the agreement is extended. And we recognize that and understand that. Your Honor, I don't know if I still have sufficient time to keep going?
You have another minute to go if you want.
Okay. And again, Your Honor, this issue of the abandonment was never raised. It was never raised in affirmative defense. It was never argued. So that issue we do not believe is properly
What is
presented.
that? Now, abandonment is an affirmative defense?
Yes, Your Honor.
I never saw that one in the rule on affirmative defense. It's certainly not listed, right?
It's not listed in the Florida Rules of Procedure as an affirmative defense, but the case is...
It's really nothing like waiver and estoppel and statute of limitations and all that stuff, right?
Well, what the cases say, though, is it is an affirmative defense.
Abandonment.
Abandonment is an...
Contract.
Abandonment of contracts is an affirmative defense. It must be closed.
Isn't it the same as non-performance?
Well...
How is it different than non-performance?
What I can say to you, though, Your Honor, and I think that there's a difference if non-performance is a breach versus abandonment saying, I'm going to make an affirmative act to not perform anymore under this contract. I'm telling you...
Why isn't that a breach?
Well...
The duty is to perform, and they're saying that he didn't, he basically quit.
But what they're saying is, they're pleading it as an affirmative sense. They're saying, even if everything you say is true, you abandon the contract, which is your typical affirmative defense. Even if everything you say is true, there's still this legal reason why you shouldn't be paid.
So everything that they say includes that the listing agreement remained in full force and effect through the date of the Miranda contract, right? I mean, that's what you had to allege. They're just denying that, right? They're saying, it didn't, right?
Right. They're saying you abandoned it. You stopped marketing the property. And the reality is...
I understand your argument.
Yeah, the reality is on that marketing issue, they never raised abandonment as an affirmative defense, but now they want to come in and hang their hat on that piece of testimony saying that we somehow abandoned the contract, and therefore we don't have a right to recover.
Counsel, your time's expired.
Thank you.
Thank you. Yeah, about 8 minutes ago.
Thank you, Your Honor, Counsel. The fact that the deposition testimony that has been so relied upon by appellee is subject to varying interpretations in and of itself cries out for the reversal of this summary judgment. Appellant simply is looking for his day in court, its day in court. The duty is on KEEWIN to demonstrate that the listing had been extended and that there was a non-expiration and so forth. I was interested in the comment about the statute of limitations, strike that the rule against perpetuities as being operative in the event of an indefinite or an undefined period for the extension. That was one of our primary arguments below. I think I argued that until I was literally blue in the face because You can't simply have an indefinite extension. And nowhere in this record, and counsel did not tell you that there was anywhere in the record that says that the extension was for a definite period of time, only until it's
Do
sold.
you have an indefinite exclusive right of sale agreement?
Don't believe so, Your Honor. I believe that
It's got to be a term agreement? It's got to be a term agreement?
it has to have some fixed.
I'll agree that you'll be my agent and you'll be exclusively appointed to sell my property until it sells, as long as you keep performing. That's not a valid agreement?
Well, I believe that the rule against perpetuities requires that there be a definite term, a life and being plus 21 years.
I never understood.
Well, what if the rule is, you'll be my exclusive for as long as I don't give you a 30-day notice? Now it's not a term, but there's a termination provision. Is that okay?
In the abstract, that might be, but that's not this case, Your Honor. This case certainly doesn't lend itself to an interpretation of that being the facts here. All right, thank you.
Thank you.
Thank you.
All right, we'll take our